debate. The Honourable Minister of Labour and Employment.
Well, thank you very much, Mr. Speaker, and it's with great honour that I rise today to speak to Bill C-65. First, I would like to recognize both chambers for their excellent work on this bill. Bill C-65 has had careful study over the course of many meetings, and both chambers have suggested amendments that are going to strengthen this historic legislation. All honourable members agree it is our responsibility and duty to end workplace harassment and violence, and Bill C-65 brings us closer to that goal. Ce projet de loi changera la
This legislation will change the way we perceive and the way we combat unacceptable behavior in federally regulated and parliamentary workplaces. But the intention is larger than that.
65 will become the standard, the model for other jurisdictions in this country. We've heard for years many stories of harassment and violence in the workplace, and just the extent of the problem. In 2017, more women than ever before came forward to share their experiences through the Me Too movement. The flood of stories was overwhelming. Some were shocked by what we heard and read, but too many of us were not. So many women have experienced what can no longer be denied, a systematic and widespread tolerance of workplace harassment and sexual violence.
The Honourable Minister, I believe we're having trouble with interpretation. Do we have sound? We have it now? Okay, I'll let the Honourable Minister continue then. Thank you.
Sharing stories cannot be where this ends. It's time for us to take action, and we are. According to an Angus Reid poll, 52% of Canadian women say they've been subjected to sexual harassment in the workplace. 28% reported having experienced non-consensual sexual touching in the workplace, and 72% of respondents who experienced harassment never reported it. In fact, these behaviors have become so normalized that the discomfort women feel is normalized. Women tell us they don't come forward because it's easier not to, because it often isn't worth it. They feel embarrassed, and many fear reprisal, up to even losing their jobs. Most disappointing is that most women simply do not believe that coming forward will make any difference whatsoever in their situation or for others. Well, Mr. Speaker, it's time for a change. All Canadians deserve a workplace that's free of harassment and violence and where unacceptable behaviour is no longer tolerated. And Bill C-65 is a tool to help achieve that goal. It's how we send the message that unacceptable behaviour in the workplace will not be tolerated. It will move us as a society from one of outrage to one of action. Bill C-65 addresses all types of harassment and violence. It strengthens the Canada Labour Code to complement existing laws and policies. It broadens the scope of legislation to include staff working right here and in constituency offices, both in this House and in the other chamber. There are three main elements to Bill C-65: the prevention of incidents, the timely and effective response to incidents, and support for affected employees. Il s'agit d'un projet.
This is a progressive and groundbreaking bill that all Canadians can be proud of. However, I am fully aware that C-65 applies only to federally regulated employees and employers.
My hope is that the legislation will set the example and the standard for fairness and harmony in all workplaces in Canada. I wish to thank the other chamber for their careful study. And I also thank the witnesses who shared their expertise and their experiences, many of them deeply personal, which helped to inform the committee's study. The Standing Committee on Human Rights took to heart the messages heard from these witnesses and proposed amendments to echo those voices and stories. And many of these amendments are supported by our government. For example, we are supporting the removal of the terms trivial, frivolous, and vexatious to describe complaints that could be refused for investigation. While these terms are commonly used in law, there is no denying that they have powerful negative connotations. There are some amendments which we are unable to support, despite the fact that we understand their intent. These concerns did not go unheard. It's the government's perspective that the amendments have already been addressed through other legislation. And my honourable colleagues will speak in more detail about each of the amendments. But rest assured, this legislation will be meaningful for Canadians. It will create better protections, safer workplaces, and swifter action for employees covered by this legislation. And it will also start a cultural shift that will affect all workplaces and our society. In fact, I believe it already has. For example, during our consultations on the regulations, the majority of stakeholders that we met recognized the need to change the status quo, and most expressed their willingness to help make that happen. It is important that as a government we lead the way, that we provide an example, and that we take our responsibilities seriously to our workers. We need this legislation simply because what's in place right now is not doing that job. Let me tell you a little bit about Hilary Beaumont, a Vice News reporter. Well, Ms. Beaumont conducted some very interesting research. She interviewed more than 40 women who work right here on the Hill, including former and current members of Parliament, lobbyists, journalists, employees, and trainees. And in her presentation to committee, Ms. Beaumont said that she quickly realized that female employees were much more vulnerable to harassment than their male counterparts. Women she interviewed reported personal stories of sexist comments and touching, and even sexual assault that they had experienced. Some women said they had been fired or had lost job opportunities after trying to report the abuses that they had suffered at work, in this workplace. Some currently employed on the Hill are not even aware about how to manage and report incidents. Ms. Beaumont discovered that existing measures are not protecting employees from harassment and violence. Well, if Bill C-65 had been in place, these women would have had better support, justice, and even better, these incidents could have been prevented. And that's why this bill is so important. From the outside, each member of this House agreed on its importance. And this was apparent during the meetings of the committee in this House, who worked very hard to strengthen the bill. Out of those meetings came important amendments, adding the definition of harassment and violence to the Canada Labour Code, adding a clause that required the provisions on harassment and violence established in Bill C-65 be re-examined every 5 years, requiring the Minister of Labour to produce each year a report on harassment and violence in all workplaces under federal regulation, and for application of Part 3 of the law in Parliament, providing the Deputy Minister with powers, normally attributed to the Minister, to avoid any potential conflict of interest. And these changes, which have already been adopted, along with the amendments from the other chamber that we propose to accept, have created a piece of exceptionally strong legislation that we can all be sure will reach its intended goals.
I am convinced that Bill C-65, as amended, will make a real difference in the lives of thousands of Canadians.
For employees in the public service and federal crown corporations. Il s'agit notamment de personnes qui...
These include people working in federal banks, railways, marine shipping and ferry services, airlines and airports, and radio and TV broadcasting.
Bill 665 will also, importantly, protect political staff. In this chamber, in the other one, where we have heard all too often, and maybe we've even witnessed, inappropriate behavior, oftentimes with the intent to humiliate, to belittle, and to use power as a way to pursue intentions of assault. I ask my honourable colleagues to support the advancement of this important bill. In fact, this historic bill. For every person who has come forward, for those who have felt that they could not come forward, let's stand up. Let's declare together that we will not accept the status quo, that we will be responsible employers in this place. Let's be an example for Canada and for the rest of the world. We owe it to our citizens, and we owe it to the incredibly hardworking staff that serve us all to take action now. Thank you. Merci.
Questions et commentaires. L'honorable député de Bellechasse.
The Honourable Member for Bellechasse, Les Ishimas-Lévis. Well, thank you very much, Mr. Speaker, and I'd like to congratulate the Minister for bringing forth an important legislative measure, an important bill for this country. We collaborated at committee. As she knows, so the Conservative Party intends to support this bill. We worked actively at committee. Now, this is a step in the right direction, but it's not enough, Mr. Speaker. Why? Because, again, employees cannot go to the department for support. What the bill will do is require companies to follow procedures. So my question to the minister is this: does she intend to go farther to include, like in the Quebec legislation, an opportunity for employees to lodge a complaint and to have an investigation that is conducted by an independent person, someone from the Department of Labour? The Honourable Minister.
Well, thank you very much, Mr. Speaker. This legislation is so comprehensive that at any time, should someone feel that the process has not been followed, they will have the ability to come forward to the Labour Department.
Comments, questions et commentaires. L'honorable député de Jean.
The Honourable Member for Jonquière. Well, thank you very much, Mr. Speaker, and I'd like to thank my colleague for her excellent speech. We worked very hard in the House and at committee, also with in a spirit of great cooperation. So this is an historic bill to work towards eliminating harassment and violence in the workplace. It's a step in the right direction. Now, I'd like to take advantage of her expertise to ask a more specific question of my colleague, dealing with Section 21 in the part dealing with annual reports. The government rejects the addition of the following. The report contains statistical data relating to violence in the workplace, namely information categorized based on each ground established under Canadian legislation. It does not include any information likely to disclose the identity of a person following an incident of harassment or violence. Now, the government feels that this addition would make it possible to disclose the identity of the person if the statistic were to be made public. So my question is this: in the amendment from the Senate, no information likely to disclose the identity. It deals with that. I'd like to know from my colleague why the government rejected this amendment from the Senate. Thank you, Mr. Speaker.
Minister.
Well, thank you very much, Mr. Speaker. And the reason why we respectfully disagree with 7B is because this amendment would be inconsistent with the Federal Public Sector Labour Relation Employment Board's other annual reporting obligations. Under both the Federal Public Sector Labour Relations and Employment Board Act and Part 1 of the Parliamentary Employment and Staff Relations Act. What it will do also is create a very small subset of cases in respect to which there are appeals. And the challenge with that is because this will be such a small subset of cases, it would take very little information to identify the identity of someone who may have been subject to those appeals. And therefore, we feel that this amendment has the unintended consequence of potentially putting in jeopardy someone's confidentiality, something that was repeatedly stressed through almost all of the testimony that we heard, that at the root of this had to be the assurance of confidentiality. Thank you very much.
Questions and comments? Questions et commentaires. The Honourable Member for Whitby.
Thank you, Mr. Speaker. I want to thank the Honourable Minister for what is a historic piece of legislation, C-65. I just want to add a dimension to it. When we think about, she mentioned that women often don't report and their stories are often not heard. And when you add the intersectionality to that, either race or disability or sexual orientation, the reporting is often a lot lower. I'm wondering if the Minister can elaborate on how this piece of legislation will allow to adjust for that, but also to make a more inclusive inclusive workplaces, not just within the federal jurisdiction, but beyond that as well.
Honourable Minister.
Well, thank you, Mr. Speaker, and my colleague raises a very important point, that not all of us are equally vulnerable, and in fact, the experience of being racialized, LGBTQ community members, people who are newcomers to this country, people who may not have English or French as their mother tongue or their first language, experience a heightened sense of vulnerability. And so having a baseline of legislation that will compel employers, first of all, to have a policy in place and to ensure that their employers know what their rights and responsibilities are, that will allow employers to take that very important step of prevention, will strengthen a fabric that sets a baseline of intolerance for harassment and violence. And we've talked a lot about sexual violence in the context of this bill, but it actually covers all forms of harassment and violence. So, oftentimes what we hear from vulnerable people is that may not be sexual in nature, but they may be experiencing harassment or bullying or belittlement based on other criteria. People with disabilities often feel, for example, that they are harassed or bullied based on a perceived ability or capacity. And so I thank my colleague for her work on ensuring that those folks who are most vulnerable in our workplaces have a strong fabric of protection and have a voice to actually ensure that they have the best chance, the fairest chance at success in their workplace. Thank you very much.
And comments, the Honourable Member for Kitchener-Conestoga.
Thank you, Mr. Speaker. Frequently in the House we hear about the importance of consultation with the various groups that are going to be impacted by legislation. And during the testimony at the Senate committee, the National Association of Women in the Law and the Native Women's Association of Canada both said that they were not adequately consulted. In fact, they weren't consulted at all during the drafting of this bill. Let me just quote from Francine Joe, the president of the Native Women's Association of Canada. She said, quote, "Moreover, there has been inadequate consultation with Indigenous people. Our understanding is this will apply to federally regulated First Nations government. And if this is correct, the Government of Canada must carry out meaningful consultation with Indigenous people." She goes on to say, "In particular, Indigenous women have not been adequately consulted. In the harassment and sexual violence public consultation report that informed this legislation, only 28 Indigenous women were surveyed, and only one engagement session with the Ontario Native Women's Association was held. Findings from these consultations do not appear to be reflected in the legislation in its current form," end of quote. So, Mr. Speaker, my question to the Minister is, does she agree with Francine Joe that there was inadequate consultation specifically with Indigenous women's groups? Thank you, Mr. Speaker.
Minister of Employment.
Thank you, Mr. Speaker. What I'm particularly proud of is this legislation will protect Indigenous women in their workplaces as well. He points out that some aspects of Indigenous communities are covered by federal regulations, and so that means this protection will be there for Indigenous women working in those spaces as well. We are comfortable with the consultation that we held. We talked to a wide variety of different experts, legal groups, advocates, employers, labor unions, and individual Canadians about their experiences in the workplace, what needed to be in the legislation to ensure a strong regime so that people would be able to use the legislation, that employers would have confidence that the tool would allow them to move forward with their endeavours without onerous measures that wouldn't result in change. In fact, we've heard overwhelming support from both FETCO, the organization that advocates on behalf of federally regulated employers, the CLC, and I'm excited to hear the comment around Ontario Native Women's Association. Their headquarters are located in Thunder Bay. I've had many conversations with Coralie McGuire, their executive director. Anything that protects women in the workplace is a step in the right direction. There is a scourge of violence against women in this country. It's really encouraging to hear a member of the Conservative Party take this so seriously. Certainly something I didn't hear in the decade of work that I did on the streets of Thunder Bay. Thanks very much.
Questions and comments? Nous avons le temps pour une question très courte, peut-être de 30.
We have time for one last 30-second question. The Honourable Member for Jonquière. Well, thank you very much, Mr. Speaker. I'd like to know what my colleague has to say about the rejection of 4A from the Senate. It would have provided an additional information to Clause 3 to ensure that the workplace is free from harassment and violence. So I'd like to hear my colleague's views on that point.
30 seconds or less, please.
Mr. Speaker, we propose that the paragraph from Amendment 4 be deleted because the addition of the proposed paragraph would mean that a single incident of harassment and violence in the workplace would be considered to be a violation of the Canada Labour Code on the part of the employer, which would undermine the framework. What we want to do is we want to make sure that we have a continuum of responses from prevention all the way up to enforcement and responding to survivors. But if we had every incident be a violation of the Canada Labour Code, you could see how this would, first of all, be incredibly onerous for employers, because in some cases those allegations may not be accurate, and it would actually undermine the framework which puts the responsibility for prevention on the employer and is such an important part of this legislation. Thank you very much.
Resuming debate.